Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today because you have a case in this court. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have is a misdemeanor case. If you had a felony case, our felony cases are normally referred to as our more serious type of offenses, whereas the misdemeanor cases are normally referred to as petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, I'm talking about not only the facts of the case, but also the punishment. That is, the punishment that you can get if you are convicted of a felony or a misdemeanor. If you are, now, felony cases are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, a state jail felony. If you're convicted of a state jail felony, the range of punishment is a minimum of 6 months in the state jail to a maximum of 2 years. You can be given a fine up to $10,000. If you are convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment, minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 5 to 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary or death by lethal injection. The case that you have in this court, as I mentioned earlier, is a misdemeanor case. Misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is by fine only. You cannot be given jail time. You only can be given a fine. Now, however, if you fail to pay the fine or if you fail to work off fine through community service, then a capious pro fine can be issued and you can be required to do jail time to sit out the amount of the fine. If you are convicted of a Class B misdemeanor, the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, the range of punishment is 0 days to 365 days in the county jail, which is 1 year, or you could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. That clipboard that you have, the first document is titled Judge's Explanation of Rights to Defendants Without Attorney, and it tells you about your right to have an attorney. Now, as a defendant in a criminal case, you have 3 options concerning your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Number 3, you may represent yourself. Now, you can represent yourself if you waive or give up your right to have an attorney to represent you. If you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney and you do not have the money to hire an attorney, you will have to fill out a financial questionnaire. Now, on the paper, on the tablet, on the clipboard rather, that you have, there's a document that is titled Jefferson County Affidavit of Indigence. That's the questionnaire that I'm talking about. You would have to fill out that questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, then you cannot speak to the prosecutor. Now, the prosecutor is an assistant district attorney. We have two of them here in court. One of them is in court now, Attorney Lamar Johnson. He's the prosecutor. Now, you can't, now, if you want to represent yourself, you can't talk to him unless you first sign a written waiver of your right to be represented by an attorney. And that should be the second page on the clipboard. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status, and employment. Now, if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document, it's titled Defendant's Choice. Mark initials next to only one choice. Now, if your choice is you want to hire an attorney, then you will put your initials on the first line to the left. If you have already hired an attorney to represent you, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. Now, if you want to apply for a court-appointed attorney, then you will put your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, you want to give up your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled Defendant. Once you finish signing your name, then you would sign the day's date on the line that's titled Date, and the day's date is April 25th of 2023. Now, for those of you who will be waiving your right to an attorney and representing yourself, you would have to read and sign the next document. The next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 25th day of April of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled Defendant, and you would date it, the day's date on the line that's titled Date. And again, today's date is April 25th of 2023. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. For those young people are sitting in that area, we call that the jury box. 6 citizens will be selected from Jefferson County to sit as jurors on your case. They will decide, after listening to all the evidence in the case, they will decide whether or not you're guilty or not guilty. Now, you also have a right to waive or give up your right to have a trial by jury. If you do so, then your case will come before the judge in one of 3 ways. It could come before the judge by way of a trial. We call that a bench trial. It's a trial by judge only. The judge will listen to the evidence, and after listening to all of the evidence, the judge will decide whether or not you are guilty or not guilty. The other way that your case can come before the judge is by way of what we call an agreed plea bargain. Now, in order to reach a plea bargain, you have to enter a plea of either guilty or no contest. Now, there are three pleas that you can enter. One, you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. And so in order to enter a plea bargain, you will be required to enter, you have to enter a plea of either guilty or no contest. Now, if that's your choice, you enter a plea of guilty, no contest, then your case can come before the judge by way of an agreed plea bargain. What an agreed plea bargain is, it's an agreement that you have worked out with the district attorney or with the assistant district attorney or the prosecutor. That case will come before the judge, the plea bargain agreement that is, and the judge will let you know whether or not the judge will follow or not follow the plea bargain agreement. If the judge does not follow your plea bargain agreement that you have entered into with the state, then you have the right to withdraw, which means to take back your plea. So for example, let's say you and the state have reached a plea bargain agreement, and the plea bargain agreement requires that you say get probation. It comes before the judge says, well, I'm not going to follow that plea bargain agreement. Then you can tell the judge, well, at this point, judge, I will withdraw my plea. In essence, I'm not pleading guilty of no contest since you're not going along with my plea bargain agreement. You can withdraw or take back your plea if the judge does not go along with your agreed plea bargain agreement. Now, the other plea bargain agreement that you can make is what we call an unagreed plea bargain agreement. An unagreed plea bargain agreement basically means that you and the state have not been able to reach a plea bargain, but you still want your case to be resolved. However, with an unagreed plea bargain agreement, that comes before the judge, and the judge decides what your punishment will be in the case. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. Witnesses sit in that chair over there that has the microphone in front of it. And what witnesses will do, they can testify for you or they can testify against you. If you're representing yourself, you have a right to ask some questions, or if you have a lawyer, your lawyer have a right to ask some questions. And we call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court in your case. By you waiving your right or giving up your right to have witnesses to come to court in your case, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses because they have filed a case against you. You also have a Fifth Amendment right against self-incrimination. What that basically means, you have a right not to testify in your case. The state, the district attorney, cannot force you to testify in your case if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your right, your Fifth Amendment right against self-incrimination, and by doing so, you will be testifying in your case. You also have a right to have what we call discovery. And what discovery is, you have a right to see the evidence that the state has against you in your case. In essence, you have a right to see the evidence that the state will be using against you in your case. We call that discovery. Now, if you're represented by an attorney, your attorney will have access to that evidence. If you're representing yourself, you will have access to that evidence. And that evidence could either be videos, audio recordings, pictures, photographs, It could be documents, it could be witness statements, it could be objects, just a whole host of other things that the state may be using as evidence to prove that you committed the offense that you have been charged with. Now, you also have a right to give up your right or waive your right to have discovery. By doing so, you will not be having access to the evidence that the state has against you. Now, as a defendant in a criminal case, you're here, you're out on bond, you're here because, well, everyone has been arrested, but however, you're out of jail on bond. You either have a cash bond, that means that you paid the full amount of cash to get out of jail, or you're on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're here on what we call a PR bond, which means you did not pay any money to get out of jail. You were released under your own recognizance. Now, every day that you have spent in jail, that jail time can be used as credit toward your punishment. So, for example, if you spent 5 days in jail, and let's say the state is offering you 5 days in jail, that means you will not have to serve any more time in jail, because the time that you spent in jail has already paid it off. Therefore, you will be given credit for the time that you have already served in jail. Now, if you spent 5 days in jail and the state is offering 7 days in jail as a plea bargain, that means you would have to do 2 more days in jail, because we'll take the 5 days from the 7 and that leaves 2. Every day that you spent in jail can also be used as credit toward your fine and court costs. You will be credited $100 toward your fine and court costs for each day that you have spent in jail on this case. So, for example, if you spent 5 days in jail, that's $500 that can be credited toward your fine and court costs. So, for example, if the state is offering you fine and court costs of $500, that means you will not be required to pay anything, because the 5 days that you spent in jail has already paid it off. Now, if they're offering fine and court costs of $700, then that means that you would have to pay $200, because we would credit it $500 toward the $700, and that would leave $200 that needs to be paid. And you would have to pay that $200 on the day that you actually enter your plea. Now, if you cannot pay it on that day, then we can put you on what is called a payment plan, which will require that you pay off your fine and court costs or the remaining balance in monthly installments. Now, if you do not have any income to even pay it off in monthly installments, then we can convert the fine and court costs to community service. And if we convert it to community service, every hour of community service that you perform, you will receive $12.50 that will go toward the payment of your balance of your fine and court costs. So, for example, if you work 8 hours of community service in one day, that's $100 that will go toward your fine and your court costs. Jefferson County has a program that is called pretrial diversion. With the pretrial diversion program, it's a first-time offender. So if you haven't been in trouble before, you do not have a criminal history, what they will do is, if you get into the program, they will dismiss your case, and then you can get it expunged from your record. Expunged means it could be erased, wiped off, or deleted from your criminal history. Now, in order to get into the program, you have to get an attorney to assist you at writing the letter to get into the program. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And again, it has to be your first offense. You cannot have a criminal history. Now, if you are a veteran of one of the branches of the military, then Jefferson County DA's office has a program that is called Veterans Court. With the Veterans Court program, again, you get into the program, you complete the program, the case will be dismissed, and you can get it expunged from your record. Now, only requirement is you just have to be a veteran of any one of the branches of the United States military. That's the only criteria, basically, to get into that program. This court County Code at Law number 2 has a program that is called the Community Safety Initiative, or the CSI program. That program is designed to address the issue of what we call recidivism. Recidivism means a person commits crimes over and over. And so to address the issue of recidivism, we have partnerships with various agencies in our community. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center. Now, the young people that you see sitting in the area that we call the jury box, that they are from Spindletop. We also have a student who's from Lamar University. Their program, as I mentioned earlier, is designed to address any mental health needs that you may have. Now, you don't have to be incompetent or found to be insane to participate in the program. A person could simply suffer from anxiety, depression, paranoid schizophrenia, a whole host of other illnesses. It could be post-traumatic stress or a whole host of other mental illnesses. Spindletop are able to address those mental health needs. Now, they will be able to do a private interview. They can do an assessment, develop a treatment plan for either outpatient or inpatient treatment. If you have an issue with drugs or alcohol, then Spindletop has a program that is called ATAR. And our local Drug and Alcohol Council has a program that is called OZAR. Both of those programs are designed as treatment for drugs or alcohol, or so their recovery program. They can do a screening, do an assessment, and develop a treatment plan, either outpatient or inpatient, to address any alcohol or drug issues that you may have. If you're unemployed and do not have a job, or if you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas that you select, then they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get a GED, then CICE program has a GED program that they can assist you at getting a GED. Now, all of these programs that I've just mentioned to you are free. It does not cost you anything. Actually, it doesn't even cost Jefferson County anything. Only thing it requires is that you have a desire to be in the program. Now, these programs were programs that I started in March of 2017, within the first 100 days that I became judge here in County Court at Law number 2. And with these programs, I always say that, we do not just arrest the problem, we address the problem. And we address the problem by taking our time, by not just giving time. And in County Court at Law number 2, we do not have court as usual. We have unusual court, and it's not because we're different, but it's because we're trying to make a difference. Now, with these programs, we believe that these programs can produce productive people. And if we produce productive people, we believe that productive people will not commit crimes. Why? Because they have too much to lose. And so if you're interested in any one of these programs that I've just mentioned, just feel free to let us know. We're going to have people coming around to talk to you in a few minutes. At this time, we have the individuals who's coming from Spindletop Center, and they're going to tell you a little bit about the program that Spindletop has to offer. So at this time, we're going to have Kristen and Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state, commissioned with the sheriff's department here in Jefferson County. I'm here with my coworker, Chris. Chris is a qualified mental health professional. The reason we are both here this morning is because the judge has graciously invited us in his courtroom because he cares about every single person that appears before the bench. The judge has found what statistics prove is those who have legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation.
Now, I know the judge has about quite a few mental health disorders. What we usually work with is anxiety, depression, things that happen in people's day-to-day lives, things that aren't necessarily easier to deal with when you're going through the court system. So outside of that, when we're talking about substance use, it can be as simple as alcohol. We do have programs over here in place, but what we also do is we work with community resources where there's a lot of them that are really well funded. They're just not well advertised, or maybe getting set up with them is a little bit difficult. If you're already juggling a lot of other things, even adding in something that can help can feel a little overwhelming.
Now, maybe this is your first time to be here. Maybe it is your 10th time to be here. There's still hope. This program works. It actually can change your life. But we're going to need something from you. That document that I passed out to everyone that came in, that document is what we're going to use to advocate for you, but you're going to have to share that need with us through communicating, giving us information where we can contact you at a later time. We can visit today if you want to do that, whatever is convenient and helpful for you. Our goal is to get you out of this cycle of arrest. Now, maybe this doesn't apply to you. Maybe it applies to a family member. If you'll continue to fill that out, we'll reach out to your family through this document and through you as well. But also, before you leave here today, I wanted to give you this brochure. On the back of it, it tells you a little bit about the advantages of the program, but also on the front, that is a 1-800 number should you ever find yourself in an unsafe place. You can get help immediately.
So one important thing about this document before we move on, it functions as a baseline give a consent form. That means the information you share on here is private. It will not be shared outside your permission. The only thing it allows us to do, as it said, is contact you once. It's not going to be a robocall situation where you get a million calls from a million different numbers. There will only be one number that contacts you, and then you can choose if you want to continue to work with us. If you have something that you need, we'll work as hard for you as you do for yourself. And everybody here already showed up today. So that 1-800 number, what's good to know about that is it is almost statewide. I know a lot of people end up in court in Jefferson County who may not necessarily be in Jefferson County. That doesn't mean we can't work with you. That doesn't mean we can't find something to help. That brochure is great to keep in general because if, say, you right now on the side of somewhere off in rural Texas, you can still call it and then they can find something to help. Any resource we work with, and the resource we can is going to be either state funded or study fees. Talking to us doesn't cost anything, talking to them doesn't cost anything. Primarily, the biggest thing to take away is what Officer Hinton said. Bring the help. That's the only thing we're here to do. I know the judge mentioned a lot of outpatient inpatient resources. We only work with outpatient resources. If you need any resources for substance use, we'll find them. If you need resources for job training, for financial, housing, food, anything like that, even if it's physical health, we don't just work with mental health. We understand that there's a lot of stress in general that comes from not being able to access what you need, and that has an impact on your mental health. So think of this as a giant wall. If you tell us what you need, we will try and find it.
So in just a little bit, the court is going to go into recess. If it goes into recess, we'll be getting this flyer into each one's hand, and we'll also be picking up those documents to be able to help you. And we'll visit with you if you have any questions at that time. Thank you very much. Thank you, Your Honor.
You're welcome. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're going to have individuals that will come around from our staff to assist you if you need any help filling out the paperwork. Once that paperwork is filled out, then the staff is going to pick that paperwork up from you. We're going to have to go through it and put you in different categories. For example, those who want their cases reset to hire a lawyer, those who want to apply for court-appointed attorney, and those who would like to waive their right to an attorney and represent themselves. That's usually take a little time. So, it doesn't take a few minutes. It takes us a while to go through all of the documents. And then what we're going to do after that point is we're going to call you up one at a time before the bench. Now, If any of you need to, say, use the restroom, there are two restrooms right outside the courtroom in the hallway. There's one by County Court at Law number 3, which is next door. That's the men's restroom. Then there's another restroom in front of the 172nd District Court, which is right across the hall from County Court at Law number 3. That's the female or the women's restroom. Again, this is going to take us a little time. Now, if you leave, say, the courtroom, do not leave the building, because if we call your name, once we start picking up all of the paperwork, if you're not here, when we call your name, then it can result in a bond forfeiture. And if it does result in a bond forfeiture, that just simply means that a warrant will be issued from your arrest, and at some point you'll be arrested and placed in the Jefferson County Jail. So this is going to take us a little time to do. And so at this time, the court is going to go into recess. And I think folks from Spindletop is also going to come by and talk to you as well. So at this time, the court will be in recess. Yeah. Okay. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M334100. Case is style of state of Texas versus Kiara Bolden. How you doing, Ms. Bolden? I'm doing fine. Ms. Bolden, I have before me, well, we have attorney Lamar Johnson is from the district attorney's office. Attorney Johnson, I have before me a motion to dismiss that was filed by the Jefferson County District Attorney's Office. Is that correct?
That's correct, Your Honor.
Ms. Bolden, the state has dismissed your case. I have a copy of a dismissal. Mr. Johnson, would you please hand this to Ms. Bolden? Ms. Bolden, your case has been dismissed. You're free to go and you have a blessed day.
Okay, do you know what they gonna do about my claim? Cause it was in my name, so I was just wondering, it's like they return it.
You would, I guess you'd have to go to the,
It's,
You would have.
like, do I go downtown?
You have to go to the sheriff. I think this was. Which department too? I think.
Oh my,
Is it the police, Baltimore Police?
yeah.
hold on, let me see.
Oh,
Let's see.
there you go.
My police department was patrolling. Yeah.
But you have to go.
Yeah, it's right.
Baltimore.
Okay, do I bring this with me?
bring that.
Okay, thank y'all.
Okay, you are.
I don't need to do anything else?
No, you're free to go.
Okay,
Thank you. Oh, no.
thank you.
Mr. LeBlanc,
Yes, Your Honor.
I see you had Kevin J. Bonin.
Yes.
He's in jail. I guess he must have had he may have had a felony case set today. That's
Okay.
why I was. Hold on a minute. Is there? Mr. LeBlanc, Mr. Bonin's case was reset to 10th, 2023 because he has a felony.
Okay, Judge.
Okay, so you're free to go on your business day.
You too. Thanks.
You're welcome.